Welcome to part 2 of this series about proving job discrimination. Part 1 was all about learning what you need to prove and making sure the law covers your situation. And to be honest, that part could be a little dry at times. For those who watched all the videos in part 1 of this series, yes, this is my 4th houseplant. I have a good feeling about this one. I've named him Ralph. And if you did watch all the videos in part 1 of the series, I just want to say, thanks, Mom. But now we've reached part 2, where I'll talk about how to prove discrimination. And although employment discrimination is not a topic that naturally lends itself to humor, that's it, that's all I've got. Employment discrimination is not a topic that naturally lends itself to humor. Anyway, in this video, I'll discuss how to prove the specific type of discrimination that you experienced, with a heavy emphasis on evidence. I'll cover the best ways to collect evidence so you avoid getting in trouble with your employer and increase your likelihood of it being admissible in court. Finally, I'll talk about how to anticipate employers' defenses so you can proactively gather the evidence you need to defeat them. As you probably know, this is not legal advice. This is going to be a long one, so strap in and enjoy the ride. Before gathering evidence, you must be absolutely clear about what you are trying to prove. Be able to answer the following questions. What type of discrimination are you experiencing? The most common is disparate, meaning different, treatment, but it could be disparate impact or reasonable accommodation. What issues did you experience? The most common are being denied hire or promotion, or being disciplined or fired. But there are many others, such as denial of a bonus, unequal wages, harassment, pre-employment medical testing, denial of training, such as apprenticeships or conferences, unequal terms and conditions of employment, like due to a dress code, an unwanted temporary assignment, an unfavorable reference, the list goes on. Lastly, what is the basis for the discrimination, such as disability, sex, or age? Jot these answers down into a few concise sentences. Be specific in your allegations. Here's an example of what that might look like. I was treated differently because of my race, African American, in that I was denied a promotion that was granted to a less qualified Asian American. When I complained about discrimination, I was retaliated against and that I was given a written reprimand. You might be experiencing discrimination in a variety of ways. Identify less important discriminatory acts, but keep your priorities in mind. Secondarily, I have been treated differently because of my race, African American, in that I've been denied a raise and denied training opportunities. The next step is gathering evidence. Proving your case depends solely on people and paper. As you're gathering evidence, stay focused on what you're trying to prove. If a decision maker took an adverse action against you, say because of your age, find all the evidence you can of that particular decision maker engaging in behavior that was ageist. Discriminatory comments made by someone who did not influence an adverse action will not help you prove your case. So, for example, if someone asked for your race in an interview, which is not a great idea, but it's not illegal, and then hired you, there's no showing of racial prejudice. In fact, courts have said that when a decision maker hires an employee only to fire them a year or two later, these terminations cannot be discriminatory, as an employer with a bias against a particular protected class is unlikely to have knowingly hired a member of that group. Comparative evidence indirectly links the adverse action to discrimination by comparing the action with the treatment of others. This is the most common type of evidence. Comparative evidence depends on finding similarly situated employees. Often, but not always, a necessary similarity is that the compared employees report to the same decision maker. When making comparisons, the more similar the employees, the better. The most relevant comparisons depend on the issue you are trying to prove. For hiring or promotion, key similarities would be prior experience and credentials. For a promotion, seniority could be significant. In comparing treatment on the job, position title, job duties, and supervisor would all be relevant. For promotion, discipline, and discharge cases, similar past performance and prior disciplinary actions is essential. Two principles apply when making comparisons between similarly situated individuals. Compare as many people as possible and focus particularly on the differences in treatment of protected and non-protected individuals by the same decision maker. Showing discrimination for certain issues necessitates comparative evidence from a similarly situated individual reporting to the same decision maker. But two employees rarely experience exactly the same circumstances. Try to find employees who are as similarly situated as possible, which might include former employees. Examine the entire context for the adverse action to assess whether disparate treatment occurred. Also, note the treatment of others who committed the same infraction under different supervisors. While a company-wide rule should be applied equally to all employees, differences in treatment by different managers does not necessarily show discrimination. If a particular manager imposes a strict interpretation of a personnel policy on all their employees, this may not be discriminatory. The manager might simply be a stickler by nature. Yet, if an attendance policy was applied harshly to members of a protected class throughout the company, but not applied harshly to others, this pattern suggests discriminatory bias. For particular types of cases, the information provided by witnesses and documents should be directed at proving the required elements of the case. To review, here are some examples of key elements in particular types of cases. In a failure to accommodate case, you informed your employer of the need for an accommodation, and an accommodation existed that would not pose an undue hardship on the employer. In a retaliation case, the employer knew about your opposition to discrimination or participation in a discrimination-related proceeding, and there was a causal connection between the complaint or participation and the adverse action. In a harassment case, you complained about the harassment to management. In a constructive discharge case, your work situation was sufficiently hostile that a reasonable person in the same situation would be forced to resign. Witnesses bring a discrimination complaint to life. They convey the effect of unfair treatment in a personal, intimate way. Detailed descriptions of the unjust actions of a decision maker are immensely compelling. Witness testimony is the lifeblood of most harassment and disparate treatment cases. Good witnesses are credible and knowledgeable. Witnesses are credible if they are trustworthy and unbiased. Individuals who are invested in the outcome of the case are less believable, as they have a reason to lie. The more detail a witness provides, the more credible their testimony. Ideally, a witness can answer who, what, when, where, why, and how when discussing discriminatory acts. Being knowledgeable, like being credible, is a matter of degree. As a general guideline, the following list ranks the importance of a witness's knowledge in proving a disparate treatment case. Directly observed, direct evidence. Experienced the same adverse action, similarly situated, in the same protected class. They're a class member. Did not experience the same adverse action, are similarly situated, and not in the protected class. They were treated better. Directly observed the adverse action, and that similarly situated individuals not in the same protected class were treated better. They were a witness. Directly observed adverse action directed at others in the protected class, and that similarly situated individuals not in the same protected class were treated better. They were a witness to the class members. Lastly, directly observed practices and treatment indicating that the employer's reason for the adverse action are pretextual, rebuttal witnesses. In most cases where witnesses figure prominently, an employer will attempt to discredit the employee complaining about discrimination, the complainant. In particular, an employer will criticize the complainant's work performance. Documents can show good work performance, but the strongest response to this criticism is supportive testimony from witnesses with supervisory responsibilities. Getting evidence that refutes allegations of poor performance is often the biggest challenge for complainants trying to prove discrimination. The following list ranks the importance of witnesses who can corroborate good performance by the complainant. Directly oversaw complainant's work during the time period the employer alleges poor performance. Direct supervisor. Indirectly oversaw complainant's work during the time period the employer alleges poor performance. Supervisor. directly oversaw a complainant performing substantially the same work as the employer criticized immediately before or immediately after the time period the employer alleges poor performance. Past supervisor, later supervisor. Worked with the complainant during the time period the employer alleges poor performance. Witness. If you don't know how others are being treated, ask around. The information you learn could be crucial for you to prove your case. When it comes to knowledgeable, credible witnesses, the more you have, the better. Other than a witness to direct evidence, which is extremely rare, the best witness is someone who has experienced the same discrimination and is willing to come forward to complain about it. An employer's typical response to a discrimination allegation is to disparage the credibility and performance of the employee. When two employees are saying the same thing, an employer's smear tactics are twice as likely to fail. An employer's credibility is severely strained when they attempt to argue 3 or 4 people complaining about discrimination are all lying and they're all poor performers. All too frequently, the individual in the best position to support a discrimination case is reluctant to come forward. They are afraid of retaliation. They fear their employer may somehow demonstrate its displeasure by denying them raises, promotions, or the like. Some people just do not want to get involved. The best way to ensure the cooperation of a witness is to have an amicable relationship with them. If you know someone or some people are going to be important witnesses, curry their friendship. Go out of your way to be nice to them. It's a good idea to try to get along with all of your coworkers anyway. When I worked as a federal investigator, I closed many cases at the EEOC where I suspected that the reasons why the witnesses were not corroborating the complainant's allegations was because no one liked the employees enough to stand up for them. You do not want to be that person. Speaking of liking, please click the like button. It really helps. Coworkers are often the best witnesses, but they also are the most likely to be hesitant to speak on your behalf. Pass along any assurances provided by investigating officials that there will be no negative repercussions. Clients and customers are also possible witnesses. Former coworkers and managers may be more forthcoming as they are less likely to be concerned about retaliation. A decision maker who discriminates against you has probably discriminated against others in the past. If your trouble started when the decision maker was hired and you reach the point where you are ready to file a formal complaint of discrimination, dig into the decision maker's past. See if you can find someone in your same protected class who worked for the decision maker at their former employer. You might be able to uncover a history of discrimination by the decision maker. Harassers are particularly likely to have harassed others in the past. There is one more category of witnesses: the people who you tell what is happening as it is happening. They can support your credibility by providing contemporaneous corroboration of your complaints. Yet, this is not the most important reason to tell others what is happening to you. Experiencing discrimination is extremely stressful. Rely on the support of your family and friends to help you get through this very difficult experience. I've listed here some emotional support resources for people who have experienced discrimination. I'm going to go through these pretty quickly, but I've also included this list in the information section of this video. Keep an open mind while compiling evidence. Sometimes, no matter how unfair and unethical an employer's actions are, they are not discriminatory. Employers have a lot of leeway in how they run their businesses. Most discrimination is subtle and difficult to prove. Proving even flagrant discrimination might depend on witness support. While witnesses flesh out a case, documents provide the backbone. Hard evidence found in documents is impervious to questions about credibility. Disparate impact cases, reasonable accommodation cases, and some disparate treatment cases rely heavily on documents. Documents exist in a variety of forms. The relevant documents depend on the issues in the case. Let me give some examples. For a hiring case, credentials, resumes, applications, job postings, advertisements, interview notes, tests, and job descriptions. For a termination case, letters of recommendation, copies of written work, an employee handbook, complimentary letters or posts, complaint letters, performance evaluations, a termination letter, disciplinary documents, and employer policies. For a disability reasonable accommodation case, medical documents, requests for accommodation, job descriptions, and employer policies. Oftentimes, you will not have access to the documents relevant to your case. If you're fortunate enough to have union representation, you can try to coax the union into acquiring documents for you. You will always have access to documents created by one extremely important person, you. From the first instance of discrimination, start taking notes. Contemporaneous entries in a diary significantly strengthens your credibility. Record the date, time, place, and what was said or done, and who witnessed the events. Judges may allow contemporaneous journal entries to be admitted as evidence in court if they were created at or just after the time of the incidents. The best way to prove that your entries were contemporaneous is by emailing them to yourself. This creates a digital record of the date and time of your accounts. Do not use your work email because your employer could have access to this information. You also don't want to use your personal email address, as that could subject all your personal emails to discovery in court. Open a free email account that you use solely for the purpose of emailing yourself journal entries. Create a journal entry each time you experience a significant event that you believe is discriminatory, which impacts your work. These journal entries should be professional, factual reports of the events. Think of this as being for court. Avoid venting at your employer or ascribing non-discriminatory motives for your employer's behavior in these accounts. Prepare for your employer's complaints about your performance by keeping a copy of documents to demonstrate the quality and quantity of the work you produced. All performance documents, positive or negative, are important to keep. Trying to hide negative performance documents will destroy your credibility. If you were instructed to improve your performance, keep records demonstrating your improvement or why improvement was impossible. Whenever you are communicating information crucial to proving your case, put it in writing. Whether you are requesting a reasonable accommodation or complaining about discrimination, clearly state this in an email. Even if the employer says they never would hire you because you're Latina, fill out an application anyway. While email is an excellent tool for generating contemporaneous documentation of discrimination, using even less formal means of written communication, like texting or IMing, are even better if your employer has a culture of using them. Many people share their opinions more freely when communicating with text or IM. You might be able to catch a decision maker in a lie or even saying something discriminatory. To prove a call was made to a supervisor or human resources, download details of your cell phone records. Cell phone companies typically keep records of calls for at least a year. Some statements do not belong in writing. If you're trying to prove you were forced to resign, don't write a warm resignation letter saying how much you loved your job. You have to prove your employer knew about the circumstances leading to your constructive discharge, so lay that all out in your letter. At a minimum, allude generally to your dissatisfaction with your employer in your resignation letter. Employers are required to keep all records relating to employment for 1 year. Once a charge of discrimination is filed with a government agency, an employer is required to retain all documents relating to the charge until the case is resolved. As tempting as it might be, copying confidential documents can have a big drawback. An employer can claim that this act is after acquired evidence and have a legitimate reason to terminate you. In other words, even if you had been terminated for a discriminatory reason, an employer can now claim a new date for when you would have been terminated, legitimately, for inappropriate activity. Damages an employer owes stop accruing on the date it discovered a legitimate reason for terminating you. Your employer already will be searching through every aspect of your employment history with a fine-tooth comb. Presenting ill-gotten evidence is a gift your former employer will be all too happy to receive. You may have access at work to crucial documents that would be impermissible for you to take home, and you're concerned your employer will destroy them. Computer systems often maintain copies of electronic communications for a period of time after they are deleted. Getting access to this information is unlikely unless you file a lawsuit. Avoid taking any actions that would create a digital record of you copying or transmitting confidential documents. All activities using your employer's email will be logged. Do not forward emails to an outside email address if that would violate your company's rules. Employers have different systems of monitoring data. You may be able to print out IM chains, emails, and attachments without detection. Alternatively, you may be able to surreptitiously print them to PDF and email those documents to an email account you create specifically for this purpose. Photos of emails are another possibility, but taking a legible picture without omitting key information can be tricky. Screenshots can also copy data, but may leave a digital trace. There are software programs that allow you to make a backup copy of the data on your phone, which could create an undetectable copy of texts and IMs. If you decide to keep a copy of confidential records for yourself, do not show them to anyone. If your employer later states these documents do not exist, you can discuss the ramifications of bringing these documents to light to whomever is advocating for you. If you do not keep a copy of confidential documents, make a list with the names of relevant documents and the dates of the emails, texts, IMs, and so forth, and keep this in a safe place. If you're worried your employer might destroy key documents or that texts and IM records will not be preserved, another idea is to make 2 copies. Hide them in separate places in your employer's building where no one will ever find them but you. If you're fired and your employer later denies the existence of these documents, you can reveal their existence to whomever is advocating for you. An employer's argument that you should have been terminated for copying confidential documents is much weaker when you never removed the documents from the premises and your employer lied about their existence. Obviously, there are some challenges with maintaining secret caches of documents at your former employer. This is a lot to absorb. You're doing great. Next up are a few optional topics just in case you're interested. If you're trying to gather direct evidence from secret recordings, compile statistical evidence, or prove a disparate impact case, the following information and approaches can be of assistance. If these situations do not apply to you, skip ahead to employer's defenses. You can use your cell phone to record conversations with your employer with a press of a button. Texaco paid $178 million to settle a class action racial discrimination case after a recording with discriminatory comments became public. Nothing under federal law prohibits clandestine recordings of your conversations with a decision maker. However, some states have outlawed secret tapings of confidential conversations unless both parties consent to the recording, and sometimes have one set of rules for recording in-person conversations and another for phone conversations. In California, both parties need to agree before a confidential conversation can be recorded. A confidential conversation is a conversation where one of the participants has an objectively reasonable expectation that no one is listening in or overhearing the conversation. Some ideas for trying to avoid having a confidential conversation are to have the conversation in a public place. If you're speaking in a private office, ask if you can leave the door open. Mention the conversation is not confidential, like, "Hi Bob, this isn't a confidential conversation. I just wanted to talk to you about why I was denied the promotion." Encourage the other party to admit the conversation is not confidential. Like, at the end of the conversation, say, "You've really given me some things to think about. You don't mind if I discuss what we talked about with other people, do you?" Wikipedia's page on telephone call recording laws include a summary of state laws about recording conversations. However, recording a conversation in California or any state with a 2-party consent law without the explicit consent of both parties is a risky proposition. If a judge decides that the conversation was confidential, you will have broken the law and could be prosecuted. California law has exemptions to this 2-party consent rule. An employee can record a conversation with prior permission of the police if they reasonably believe that they will be threatened in the conversation. Also, a judge may allow an illegal recording to be admitted into evidence in court if it's being used to discredit a witness who has committed perjury, that is, lied to the court. If you are able to get a legal recording of direct evidence, this can put extreme pressure on an employer to settle. Statistical evidence requires quite a few decisions in order for it to be reliable. In a small company, finding statistical evidence may be impossible. Generally, the bigger the group being analyzed, the better. But this is not always the case. Inspecting the promotion rate of women for an entire company might obscure the discriminatory promotion practices of a particular sexist manager. hiring cases rely heavily on statistical evidence, especially because there is little other available evidence. If the company's advertising for positions is discrimination-free, one measure of the hiring disparity is through applicant flow. Applicant flow is the pool of people who applied for employment to the company. If the applicant flow showed 40 of 80 applicants were women, but only 2 of 10 hires were women, that would be good statistical evidence. An employer remains responsible for discrimination resulting from a policy even if the employer did not intend to discriminate. Of course, the protected class must be adversely affected because of the policy or practice. Requiring educational credentials, including degrees and certificates, can create a disparate impact. If a protected class does not have the required credential at a rate equal to the general population, a disparate impact results. The required credentials must be job-related, meaning related to a specific job under consideration. They must also be consistent with business necessity, which means they are necessary to show the applicant can adequately perform the job. Here's an example from a case decided by the Supreme Court which helped define disparate impact. Duke Power Company required laborers to possess a high school diploma. Requiring a diploma had a disparate impact on African American males. The diploma was unnecessary for the positions. At that time, only 18% of African American males in North Carolina held a high school diploma, as compared with 34% of white males. At times, disparate impact cases result from tests conducted by employers. Tests administered by an employer must be valid and measure established job criteria. Skills, knowledge, or abilities related to job performance are legitimate job criteria. Validation of tests can occur in a variety of ways. A simple form of validation is by replicating job duties. A test that replicates key job duties would be valid, like requiring a court reporter to take a typing test. Although highway patrol officers need to sketch accident scenes, a drawing test would be too limited in scope to accurately determine the qualifications of an officer candidate. Employers cannot test for socially desirable traits like intelligence and honesty. Employers may wish to test for a psychological trait or characteristic that is necessary for a position, such as compassion for a doctor, but the test must prove the correlation between the characteristic and the job performance is statistically significant. As this is extremely difficult, employers rarely attempt it. Written tests have additional restrictions. These tests are unlikely to be valid for jobs that do not involve writing. Truck drivers need to know how to read a map, so a map reading test is job-related. Written tests must use a specific cutoff score as a passing score. Using written tests to develop a ranking is only valid if the employer can show that variances in test scores directly align with degrees of successful performance. If a position requires a group of tests, a single test can be challenged for creating a disparate impact if the test disqualifies an applicant from further consideration. If an overall score is calculated for the entire group, then the applicant must challenge the entire group of tests. After you fulfill the necessary prerequisites to establish the appearance of discrimination, a prima facie case, your employer will provide non-discriminatory reasons for its actions. You will need to disprove these reasons. To prove your employer's position is not true, you need to establish that your employer's explanation for the treatment is inconsistent with processes and criteria it relied on in past decision-making. Examples of inconsistencies are not following internal policies, like a progressive disciplinary policy, and not following customary practices. Inconsistent explanations, particularly those that contradict one another, help prove your employer is not telling the truth. If you apply for unemployment, your employer may need to provide the state unemployment compensation department with the reason you are no longer working. This response may contradict the reason it provided in response to your discrimination complaint. If your employer immediately hires another employee after terminating you, it demonstrates its actions were planned in advance, possibly contradicting other explanations it provided. Employers' defenses in discrimination cases tend to be pretty similar. The best way to beat these defenses is by anticipating them and gathering evidence to refute them before your employer is notified of a discrimination complaint. Here are some examples of defenses favored by employers and how to respond to them. The employee's facts are not correct. Deny, deny, deny. This is the most common defense. You can expect your employer to insist you are mistaken or lying. While your employer will likely raise this defense in response to all of your allegations and evidence, this is the only viable response to direct evidence. Beat this defense through witness corroboration and good documentation. Compared people are not similarly situated. This is the second most common defense and an employer's stock response to comparative evidence. Your employer may attempt to portray you as incompetent or unethical. Your employer may peg you as a poor performer to erode your credibility, even in the absence of comparative evidence. Your employer will likely list every minor infraction you ever committed, including a few you've never heard about. The importance of every verbal warning and written reprimand will be inflated until your employer appears kind and generous to have given you so many chances. I remember investigating one case in which the employer stated, quite convincingly, that the person who filed the complaint, the complainant, had a history of tardiness and absenteeism. The employer provided dates of 14 different infractions during a 3-month period. The reasons for the complainant's termination seemed convincing. But upon looking more deeply, I discovered that all the absences were cleared by a doctor's note, and the complainant never showed up to work more than 2 minutes late and often arrived 10 or 15 minutes early. Documentation of being a good employee, such as letters of praise, awards, and positive performance reviews, help to beat this defense. After trashing you, your employer likely will argue that the person you identified as receiving more favorable treatment is completely different. This other employee might be described as a stellar worker without any verbal reprimands who performed the job outstandingly well. Your employer may say you were qualified, but the other person was more qualified. Expect your employer to accentuate any differences between you and your coworkers who received more favorable treatment. Every differing credential or responsibility of the employee who received more favorable treatment may now be the main reason for that preferential treatment. This defense can be defeated through a careful scrutiny of the applicability of these credentials and responsibilities to the actual job duties. The position description and similar documents can show that differing credentials or responsibilities are trivial in importance. Excellent supporting evidence is testimony by individuals in a position to evaluate the performance of you and the similarly situated person and who rates you as a better performer. Good supporting evidence is witness testimony stating that differing credentials or responsibilities are irrelevant. Documents showing qualifications superior to those of other employees are also good. Your employer might argue that you're not comparable with your peer because they have a different manager, are in a different department, or are dissimilar for other reasons. If you've identified others with the key similarities I discussed earlier, you'll have no problem defeating this aspect of your employer's argument. Other similarly situated people are not compared. This defense is usually not compelling, but in rare circumstances, this defense is quite strong. By raising this argument, an employer attempts to show that similar adverse actions were taken against other individuals who are not members of the relevant protected class. If faced with this argument, your response should be similar to what the employer attempted in the previous defense. Either you did not commit the same infraction as the employees identified by the employer, or those employees committed worse offenses. Overcoming this defense is harder if your employer cites examples of individuals in your protected class who received favorable treatment. If you compared yourself with as many similarly situated individuals as possible, this defense should not pose a difficulty. Favoritism or nepotism. This defense against comparative evidence is rarely used, but hiring, firing, or promotion cases can be undermined by this defense. The employer responds that they treated the compared individual favorably because they are a close friend or family member. On a one-time basis, this is legal, barring any direct evidence of discrimination. Hiring friends and family is not legal when statistical evidence shows a pattern of discriminatory behavior. A weakness of this defense is that it restricts an employer from fully using the first two defenses. An employer would be conceding that you were performing well or were well qualified, but still subjected you to an adverse action. Particularly if the individual receiving the desired treatment is not a family member, this defense is open to attacks about whether the nature of the personal relationship actually motivated the preferential treatment. If the recipient of the preferential treatment was romantically involved with the decision maker, this may indicate quid pro quo sexual harassment. Statistics are not meaningful. An employer's most common response to statistical evidence is that the statistics are worthless. Your employer has no viable response if your statistical evidence includes the two percentages discussed previously: protected people who experience an adverse action versus those who potentially could have experienced the adverse action. The policy is job-related and consistent with business necessity. To defend a policy with a disparate impact, your employer must prove the policy is job-related and consistent with business necessity. The policy must relate to work, have a purpose that furthers the need of the business, and your employer must be unaware of a less discriminatory option that would accomplish the same purpose. One more thing. Employers often believe customer preference is a reasonable defense, but proof that your employer took any kind of adverse action because of customer preference strengthens the case immensely. Now that you know the evidence you need to prove the employment discrimination you experienced, you can estimate the strength of your case. Keep this evaluation in mind, as it may affect some of your future decisions, such as whether to file a charge of discrimination with a government agency or whether to accept a particular settlement agreement. The most immediate decision you may need to make is whether to complain internally. In the next episode, I'll walk you through when and how to file an internal complaint with your employer. What's that? Ralph wanted me to tell you, thanks for tuning in.